a service offence to include offences under the Act and those under any other act for the time being in force committed by a person while subject to military law. And the Supreme Court has pronounced on this in Attorney General versus Uganda Law Society, at page 10. And in that case, it was a unanimous decision of the Supreme Court arising from a constitutional appeal. They only required that for an offence under an act other than the UPDF Act to be within the jurisdiction of the General Court Martial, it must have been committed by a person subject to military law. And what they required was to allege and show that the accused persons committed either of the two offences while they were subject to military law. That is the link they require. And the applicants have not shown that that link is not in the charge sheet, and it is the burden on them to show that there is no link. It is not alleged that these people were subject to military law. We also wish to point out that there are procedural safeguards for the trial of persons before the court, including presumption of innocence, burden of proof, and these are matters for a trial court. These are not matters that require constitutional interpretation. With that, I hand over to my colleagues to continue.
Much obliged, my Lord Chairman. My Lord Chairman, I would like to back up the submissions of my learned friend, Captain Ambrose. I'll begin by quoting Article 132, Clause 4 of the Constitution. It says that the Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. Although the Supreme Court has severally decided that these courts have jurisdiction to try the accused persons, and my learned colleagues on the other side repeatedly citing the decisions of the Constitutional Court would be in contravention of that specific article. And I will reply to the other general issues, specifically on Regulation 63, Regulation 2, and Regulation 69. Lord Chairman, the General Court Martial operates under a framework of the UPDF Act, which ensures its independence. The Act provides a clear separation between the administrative functions of the High Command and the judicial functions of the General Court Martial. My Lord, I refer you to section 14 of the UPDF Act, Cap 330, and section 195, so it establishes the General Court Martial. But while the High Command may oversee the general military administration, it does not interfere with the judicial making process of the General Court Martial. Members of this court, including its chairman, are carefully selected and sworn to administer justice without fear or prejudice. You know, this is under Regulation 14 of the Uganda People's Defense Forces regulations. They are guided by the principles of fairness and impartiality enshrined in the Constitution, Article 28, and the UPDF Act. The presence of the legal officers and adherence to established legal procedures further guarantees impartiality of the proceedings. This court has autonomy in its decision-making process. It conducts trials based on evidence, law, and legal principles, not directives from the High Command. The decisions rendered, furthermore, the decisions rendered are subject to appeal and review by superior courts. By superior courts, I mean the Court Martial Appeal Court. This is provided under Section 225 of the UPDF Act. The relationship between the GCM and the High Command is administrative, not judicial. The High Command's involvement ensures logistical and institutional support for the court martial, but does not extend to influencing judicial outcomes. Now, concerning Regulation 63, Sub-Regulation 2, it is very clear the role of the judge advocate is to advise court on matters law. If the court disagrees with the decision, they shall record in the proceedings in its reasons. It does not mean that they are entirely binding, as one of the colleagues on the other side alluded to. My Lord, I give way to my other colleague to submit. That is all.
Lord Chairman, honorable court members, I will straight away go to the question that was framed by my colleagues, especially question 6 on the arrest, rendition, and trial of formerly two accused persons, that is Colonel Retired Dr. Besigye and Haj Obeidul Taleh. Madam Chairman and honorable court members, the ruling that was rendered by this court today morning settled that. And in that ruling, the court clearly pronounced itself in as far as the arrangement that is between the two countries, that is Kenya and Uganda. And my Lord Chairman, that arrangement is backed by the law. It's backed by the East African Community Treaty, of which Uganda is a party. Not only being a party, but it also domesticated that treaty. And the same thing with domestication was done by our neighbors, that is Kenya, also domesticated that treaty. So, Madam Chairman, under that treaty, specifically under Article 124, that addresses the protocol of peace, on peace and security. And the article outlines the commitment of partner states to cooperate on issues related to peace and security. And my chairman to into motion or to put into practice that cooperation. That's when we see the coming up of that memorandum of understanding for the two states to cooperate on matters relating to security and cross-border crimes. Therefore, we also refer to this court the authority that my brother and senior colleague, Councillor Kwago, alluded to, the one of Amar, Awad, Umar, and 10 others. And my Lord Chairman, that's a very good authority, because it clearly highlights the role of states that are parties to the East African Community Treaty. And if I may, on page 70, page 71 of that judgment, my Chairman, under paragraph 30, if I may read verbatim, states that we also observe that East African Community Treaty was domesticated in Kenya, Tanzania, and Uganda. In Uganda, Parliament enacted the East African Community Treaty Act of 2002 by virtue of statutory instrument number 29 of 2005. The East African Community Act Commencement Instrument 2005. It came into force apologies, I think I misplaced the paper. But the argument I'm making is that there indeed exists an arrangement between the two states, the two partner states, that is Kenya and Uganda. This one was confirmed by authority that was clearly and well cited by my senior colleague, though with blood interpretation from his side. But be as it may, my Lord Chairman and honorable court members, we submit that indeed the laws were followed. In other words, in the absence of the extradition treaty between Uganda and Kenya, this law applied squarely on both countries. My Chairman, also, and that one would not really need a reference to interpret, otherwise it would be a waste of court's time. My Chairman, on the other issue, which issue 2, and my senior colleague earlier alluded to it and submitted on it, but maybe to add something that is that might be important. we really rate all the authorities that were provided to us by our colleagues. And two things are cut across in all those authorities, and my colleague Gorpo talked about it. There is a recent ruling. This one you may not need to refer to the Constitutional Court. And that ruling was very clear, staying the execution of the Kabaziguruka case findings. It is as plain as that. You don't need to refer to court that interpret this or try with civilians. It would be absurd, very absurd. And my chairman, further on that, we also confirmed that indeed the decision, the authority that was cited by Steel Council Lukwago, the one of Abdunur Semuju aka Minana, the issues that had been raised in Kabaziguruka case were the same issues that were raised in Minana, and he can testify, he argued it. So, my Lord Chairman, it would be defeat of justice. And not only that, but also wasting court's time to now also apply to stay the execution of Minana. Though there has been an appeal, we are aware, and Council Kwago is also aware that there has been an appeal against the decision of the Constitutional Court. And we are yet to know the hearing dates. But, my Chairman, we submit that we base the trial of civilians in this court on the decision or the ruling staying execution, the decision of Kabaziguruka. And therefore, in this matter, Minana cannot really suffice. It can't. As I conclude, my Chairman, and court members, I would also like to add something on the question of impartiality that my colleague talked about. That whether the General Court Martial can be impartial on adjudicating of matters before it, and reference was made to Article 28(1). My Chairman, my colleague addressed that, but to add something, under Section 207 of the EPDF Act, where rules of procedure and evidence that apply to civil courts can as well be applied to General Court Martial. That is in the law. And my Chairman, that goes back to interpretation of a provision of the Constitution is required. But Chairman, what we saw today in the framing of questions was an appeal in disguise. An appeal in disguise. The questions, the way they are framed, we would actually say that the counsel for the accused persons would go under the Commercial Appeal Court rules to appeal against the ruling that was rendered today morning. Other than casting a net, let us see what comes out of the lake. The court does not operate like that, Madam Chairman, and I pray that you should not allow that to happen in this court. Madam Chairman, that was also emphasized recently, Constitutional Court reference number 31 of 2010, that is Uganda against Francis Atugonza. And court stated that constitutional reference by the court that is determining the cause or a party to the proceedings who request the court, it goes back to what my colleague and senior Counsel Karibara stated, that the court, so the hands of court are tied, quite absurd. They are more. That's why you're here. No, Chairman, that statement itself, it simply puts a constitutional court into a position of applicability of the law, of the rules, which I disagree with my colleague. The constitutional court can apply the law in other cases, but as far as constitutional reference is concerned, it's basically interpretation, not applicability. Not applicability. Applicability is with the authority of court. Now, whether the court, I'm not saying this court, whether the court, any court, applies the law regularly, that is a different matter. And there are channels. You appeal. You appeal. That's what he told me. Now, and lastly, Madam Chairman, we pray that
Thank you, Nathan.
unless the law assists him, but Madam Chairman, lastly, we pray that from my side, because my senior colleague is going to give it a final push, we pray that you really be pleased with us on the law, and especially where you are satisfied with the decision to the ruling of court where you are supposed to go. So, and my colleague, my senior colleague is going to bring this home.
Chairman of the members, I associate myself with my young brothers, and I have something to add. In regard to impartiality, when you look at Article 142, appointment of judicial officers, paragraph 1, the Chief Justice, the Deputy Chief Justice, the Principal Judge, the Justice of Supreme Court, Justice of Appeal, and the Judge of High Court shall be appointed by the President acting on advice of the Judicial Service Commission and with approval of Parliament. Now, our honorable colleague,
Nathan, texting on my WhatsApp. I have to add you in extreme media group, Nathan.
So, you cannot neglect the fair trial of this one. The same person who appoints these justices and judges is the same person when you look at the section 194 of the PDF. The same person that appointed the board members, the instrument which you read to the accused person, that is the commander in chief, who is the president, and is the same person. So where is impartiality in that regard? So that one does not require any constitutional interpretation. Section 208 was also attacked of the UPDF Act. I want to draw you to look at section 4 of the Penal Code.
Subscribe, like, comment and share the link. You watch Extreme Media Yuki.
Section 4 of the Penal Code Act is about the extent of jurisdiction of courts, and it states the jurisdiction of the courts of Uganda for purposes of this code extends to every place within Uganda. Notwithstanding subsection 1, the courts of Uganda shall have jurisdiction to try offences related under section 23, 24, 25, and 26 committed outside Uganda by Uganda citizens or person ordinarily resident in Uganda. For avoidance of doubt, the offences referred to in subsection committed outside Uganda by Uganda citizens or a person ordinarily resident in Uganda shall be dealt with as if they had been committed in Uganda. And those under those sections, those offences are treason and aiding military police officers, that kind of offences. And now when you go to section 3 of Anti-Terrorism Act, section 3 of Anti-Terrorism Act, the territorial jurisdiction of courts of Uganda in relation to offences under the Act. The courts of Uganda shall have jurisdiction to try any offence prescribed in this Act, where committed, if the offence is committed in Uganda or outside Uganda. So, it's the section puts down all circumstances under which the offence can be committed. The offences committed outside Uganda, to which this section applies, shall be dealt with as if committed in Uganda. So, this section is almost the same wording as section 208 of the UPDF Act, where these officers are asking, where do we get the jurisdiction to try an offense which was committed in Kenya? So it is Iran. It's not what is special about this. It's not the news. What should be interpreted by the Constitutional Court.
Nathan, thank you so
So
much.
jurisdiction extends outside Uganda according to the statute. And we earlier stated that jurisdiction is a creature of statute. Therefore, there is no need for such a section to be referred to the constitution for interpretation. What would you be interpreting? My Lord Chairman and all court members, we do believe that our honorable colleagues are aware. We are citing Kabasuka case, but they are aware that that case, if you are to implement it, there must be execution. You go and extract execution order. And if you get that order, we would not, this honorable court would be, it cannot proceed in trying the civilians. If an execution order, and you know how to get execution order. If you don't know, then you need to identify some your criminal procedure. So it would be frustrating the highest court of the land and read verbatim how they in Jerusalem, we allow application and make the following orders: execution of and or giving effect to the orders and declarations issued by the Constitutional Court in Constitutional Petition number 45 of 2016 between the parties hereto are stayed until disposal of applicants intended appear. Who are you to go against the order of the Supreme Court? Chairman and all board members, that is the position of the law. And if we, in the case it is not, if we don't proceed, personally I think I could even be prosecuted to give a reason that we don't have jurisdiction. Chairman and all board members, until otherwise, as of now, we have jurisdiction. So please, no matter that you will find again for constitutional interpretation.
Thank you so much.
The fact I think the issue of error. The issue of error. First of all, it did not arise from the ruling of this court this morning. This was a different matter. Court never made a ruling in regard to Jesus error, and court determined, pronounced itself, and it is purpose of this. So there is no way out this court can again turn the same point of law to interpret what happened in that ruling.
Ivan, for the record, and in rejoinder, I'll be brief. The beauty about attending class is that some learn and some do not learn.
Listen.
Council Kalivala, Council Mbanga, Council Kalua, and Council Lukwago went into further detail about the constitutional provisions, the questions vis-a-vis the UPDF Act and the Constitution. I am disappointed that they might not get a financial benefit for that, but they offered it free of charge for us all to hear and listen. The actual fact that we sit here and says that does not face a question, that is a question, is the actual reason as to why we should be in the Constitutional Court on such matters pertinent to this matter. I also want to state in general rejoinder that it's not the duty of the prosecution to frame questions that we want the Constitutional Court to address. And nor is it the duty of this Honorable Court, with all due respect, to usurp powers of the Constitutional Court under 137 to interpret questions posed by the parties. I also want to state unequivocally that there are two legs within the Constitutional Court. If it may please you, I will substantiate on the two legs. On the two legs, there is one where the court deems it fit to raise a constitutional question. That is one leg. And in the wording of the Constitution, they use the word may. I believe that you as officers of the UPDF understand command, order, and all that. The second leg of that Constitution, Article 137(5)(b), gives latitude to the parties to escape the tyranny of a court, tribunal, or a disciplinary committee by allowing the parties to pose a constitutional question. And we didn't move under the other leg one. We used leg two to protect and defend the rights of the accused person. And that leg in the Constitution, it says shall. It is coiled in mandatory terms. The Supreme Court has been in position to guide in a number of authorities about the coiling of the Constitution and the word shall and may. And the framers of the Constitution, of which Dr. Besigye, one of the accused person, was, is very clear and instructive. So it's our duty to ask that the professional UPDF under Article 208, the profession and professional soldiers should respect the command and the supremacy of the Constitution, of which we are all here to defend. Members of the General Court Martial, I also want to mention that when the prosecution wants to phrase its own questions, it shall present them before the Constitutional Court. We have framed ours, and we are saying this matter warrants a constitutional interpretation. Members of the tribunal, I do not understand the obsession with the Kabazukoro case. My senior has already alluded. I said the General Court Martial, tribunal, or any disciplinary committee. And with the word court, if it appeases your ears, I shall maintain that. Professionalism means respect to the rule of law. None of you will be hurt, or there is nothing for you to lose if you refer our questions to the Constitutional Court. And in the way, counsel lied to this honorable court by saying that these court's hands are not tied. Actually, they are tied with chain and shackles. And I will address in broader perspective about the MOU you talked about. That MOU is alien to us, and it's not anywhere within our knowledge. All that we are so sure of, Article 79 of the Constitution only gives powers to Parliament to make laws, and also has a condition that no one else can make laws that have force in Uganda. Whoever that MOU might have had his own wishful desires, and that's not our problem. Our problem is that the law of the land must be enforced the way it is to the land. And also, in the most severe, I want court to take judicial notice under the ABS Act, as taught by Senior Kalibala, that even in the most cases of Jamilu Nkulu, there was an extradition from Tanzania. As to whether the accused person did not enjoy that benefit, is also another phenomenon we are about to explore. I also want to state that the issue of impartiality has been largely misunderstood by my colleagues. It's not about the members of the court, no. It's about structural issues rooted in the UPDF Act vis-a-vis the Constitution of the Republic of Uganda. We do not have any desire to impute the credibility of the members of the panel, and we have less appetite for that detail. I also want to state that, having said so, these are our questions as to whether they desire to make submissions challenging any of them. Unfortunately, none is qualified. None of us is qualified. To do that, safe from the Constitutional Court. And trying to do that is violating and usurping the powers of the Constitutional Court and molesting, defying the Constitution of this Republic. The idea that we court covers Guruka and leave other cases that have been decided and not appealed is appalling, and should be the duty of the officers of the UPDF to maintain the stature or the desire for the UPDF to be a professional army. And finally, when a matter arises, when a constitutional matter arises, it has to be referred for interpretation. Otherwise, again, I state, none of us is qualified to interpret the Constitution. And another rider is failure to respect the interpretation of the Supreme Court, also tantamount to violation, molesting, raping, defiling, and abrogation of the Constitution of the Republic of Uganda. We desire, it's our desire, that we do not want the UPDF and its institutions, most especially the General Court Martial, to trade and train that way. Again, we do not know about that MOU being quoted. We do not know it as under the laws of Uganda. We also do not. We are certain that it did not conform to Article 91 of the Constitution of the Republic of Uganda, and whoever made it can as good as use it to light a fire and a charcoal stove for their own benefit. Thank you so much.
Guys, subscribing, liking, share, commenting.
This court, I want also to take this latitude to add on my voice as the defense team for Dr. Besigye. It is quite very paradoxical and various for prosecution to allege what was shown in the jurisdiction that this court has interpreted and reached. Whereas we take evidence of the fact that the Constitution of the Republic of Uganda ushered in this General Court Martial to peacefully go to handle cases regarding the discipline of the. It is not true that because by virtue of that very enabling provision of the Constitution that you have jurisdiction for these questions. I would love to implore this court to adopt this decision while the Constitutional Court was faced with the same similar matter in the case of Honorable Sam case and which we are prior in the morning while submitting the same was submitted by the defense team, that is by Counsel Kalibala. The House of Lords in this case, while elucidating on these facts, we are able to persuasively adopt the decision in the Namibian case of State versus Johnson, 1991, volume 20 essay at page 813, and it was in the effect that the Constitution is the catching word. The Constitution of the nation is not simply a statute, which mechanically defines the structures of the government and the relationship of the government and the governed. Those are the few catching words. It is a mirror of reflection. When you go to a mirror and you put in front of you, you can easily see what is happening in you. So this is a mirror of reflection, reflecting the national soul of the identification and the ideas and the aspirations of a nation, the articulation of the values bounding its people and displaying its government. In summary, therefore, as I invite this honorable court to adopt, and they should respectively adopt these decisions. These decisions act as jurisprudence, they are binding precedents. This is a decision from the Constitutional Court. This is what the House of Lords had to say, that in interpreting the Constitution, that's why I'm differing from the view of my land friends. They are trying to hoodwink and mislead this honorable court, which we totally disregard. That in interpreting the Constitution, the rule of harmony and completeness requires that the constitutional provisions should not be looked in isolation, but rather the Constitution should be looked as a whole document. That's why it is because of the Constitution is referred to as the ground law. Article 2 clause 2 of the Constitution is very clear. If any law is inconsistent, is repugnant, any regulation, including the one which this General Court is citing, if it is inconsistent, it is contrary to the provisions of Article 2 clause 2. The framers and the promulgation of that very article were alive to the fact that certain issues arising out of during proceedings like civil might arise. That if any law, if any regulation which is inconsistent with that very particular article, it should be declared null. And it is because of that very same article that we are trying to invoke Article 137 to enable us to refer this matter for reference. So it is misleading and it is quite very paradoxical. I humbly request that this honorable court to please associate the submission of the prosecution that miserably failed at any stage with any item of evidence to prove their case. I so beg.
Honorable Chair and honorable members, I am grateful to my son friends on the other side. Because in my view, they have not dealt with any of the issues raised. I'm grateful that they have made our work with this. Past the stage in this country where we should have mechanical responses to the issues. Just say no because I can say no. I should say no because it is value in the position that I have adopted. I have listened carefully to what my land friends have said, and a lot of it sounds to me like the arguments you invite them to make when we go, hopefully, when we refer to the Constitution. Because those arguments will be very important in that as it interprets the articles that we have cited. Honorable Chair, we did say in our submissions initially, the questions around impartiality have nothing to do with the 5 members who are in this group. It's not personal. We have no doubt that the gentlemen and lady officers who are at this group are fine gentlemen. But the regulations we cited, they are laws, they are not immediate. I appreciate fully the idea that the High Command and the General Marshal have different roles. I read a rule which says that the High Command can consult on matters of law. I haven't heard, I think it's 69, I haven't heard the response that says it can't. If we take it to the other side where we are used to appear, there is no similar provision where a judicial officer, also appointed by the president, can consult. It doesn't sit down particularly with the idea. So it's an institutional issue, it's not a personal issue. It has nothing to do with the gentleman before whom, the ladies before whom. It's the only one that equalizes all of us. Only one. Where everybody can look and say, I am equal to this one, in that document. So we find comfortable with some of these things that trivialize, especially where they have to do with the Constitution. This is not a petition that we are asking to debate, this is a reference. There is a reason why we have a difference between petitions and references. And what I honestly expected my learned friends to do was to enrich the questions so that we go together and come back together better enriched, knowing where everybody can trade, so that we are not working on eggshell, nobody is working on glass, nobody is. That's what I expected. That they would come and say, the phraseology is not proper. Honorable Chair, this is a better phraseology. Because that appears to us to be what must happen when Article 175 B is important. So I would invite the Honorable Court to consider those questions as posed, and perhaps also just put another small matter to rest. The question of how you refer. There has been reference made to rules on petitions and references. That is the stage we will get to when the reference is being made, because there is a formal document. It will be presumptuous of us to raise the questions and then just proceed in the face. We would have been hoping that we would have agreed together with that date, so that we focus on what the court will submit. The questions that we posed were our proposals. The point authority appoints many people. But if an ambassador were appointed and is given, allowed to exercise judicial power, we would argue the same things. Although they were appointed by the same. If another DC attempted to exercise judicial power, also appointed by, we would argue the same thing. We are just dealing with matters of law. They affect laws. of all of us. Today, tomorrow, in the future. So we shouldn't deal with them lightly. They are serious. Lastly,